this meeting, 507, Committee of the Whole, looking and considering ordinance number 10. I think there are a few council persons with questions and concerns or comments. I think to make it streamlined, I'm going to follow what Councilman DeBrango did and go section by section, and then allow for those highlight points if there are any, and then move forward in that way. It's a 12-page document. I think that's the easiest way to get through it all. I don't want to miss a section, but I also don't want to read line for line. We've had this document for some time, and I do recognize that time is valuable to you all. All right, ordinance 10, ordained chapter 214 of the Code of Ordinances of the City of Utica is amended hereby further amends to read as follows: licenses and permits, miscellaneous businesses regulations, neighborhood retail certificate of use. The purpose of this article is to establish regulatory controls to ensure that certain businesses are operated in accordance with law and do not have negative impact on surrounding residential neighborhoods or do not endanger the health, safety, or welfare of persons in the city. All right. In terms of section 214.337 definitions, does anyone have any problems with any of that language?
I think I do.
Okay.
This is council person friend. Unfortunately, I have it somewhere in my world. There is the copy of this legislation with copious notes on it, and I can't find it. And I'm at the end of my wits. But I have a question about how we're defining these stores, and I want to know what keeps a Walgreens from being, are we capturing the Walgreens and the Rite Aids in this? And I'm looking specifically where it says neighborhood retail establishment. So the third paragraph in 214.337. And it says, and prepared food sales to be used and consumed primarily off the premises. So my question is, one, are we capturing Walgreens in this, which I think would be odd. And then two, my question is it all that a store would have to do to not be caught, to not be subject to this regulation is to no longer sell food that somebody can take with them and eat out off the premises? Because given the intent, what I understand to be the intent of this legislation, the people who we're trying to regulate are going to be looking for loopholes, and that would be the easiest one for them to take advantage of. Stop selling hot dogs. Now we're not your kind of store. We're not the kind of store which is regulated by this ordinance. And so we're good to go. So those are my two questions.
If I can respond to that, this is Brian Thomas with the city. I have with me Patty DeCarr from my office, as well as Eric Crossman and Chris Lawrence. All of us have been intimately involved with both the drafting of this legislation as well as the rezoning, citywide rezoning map and zoning ordinance. Councilwoman, to answer your question specifically, the 6,000 square feet is intended to draw the defining line between a neighborhood convenience store and a larger retail store such as a Walgreens or a Price Chopper, Hannaford. 6,000 square feet is fairly small. And that's gonna keep it to just the neighborhood convenience stores.
Okay, thank you. So I'm not very good at thinking about how big 6,000 square feet is. So you're saying like the Walgreens in my neighborhood on Genesee is larger than that?
The Walgreens, yeah, that's probably about at least 10,000 square feet, if not larger.
Okay, very helpful. Thank you, Mr. Commissioner.
You're welcome.
Mr. Commissioner, this is Councilman Beatrice, and also to Celeste's point, isn't this more like she speaks Wegman or the Rite Aid or Walgreens? Now, wouldn't those be considered like drug retail? That's not considered in the same segment that we're talking about, or is that something out of my work history where we break things differently by the chains of stores? I'm under the impression this is for small little, convenience stores, right? We're not talking about
the larger stores would fall under the general retail definition in the proposed zoning ordinance.
Okay, and it doesn't necessarily, I mean, even these stores here, the food part of it I mean, that's part of it, but it's basically, if they didn't sell food, they're still going to fall under whatever we come up with. It's correct. The food part is
Correct.
not the main part of this legislation.
Correct. The food part, the consuming food off premises is just one element of it. It doesn't have to apply to every single store to fall under this definition. It's really the sale of dry goods and foods and beverages.
Okay, thank you.
So with this definition, would a coffee shop, because we've had those concerns, I think about all of those small coffee shops, would those coffee shops or small eateries be under this neighborhood retail establishment?
No, they would fall under restaurants or cafes.
Okay, very good.
That was one concern when we were drafting this legislation. We spent a lot of time focusing on this definition because we didn't want to catch up every single retail establishment. We wanted to focus strictly and specifically on corner stores because that's really the issue that we found through the last several years in trying to regulate those specific stores. It's not the Walgreens that are causing issues. It's not a coffee shop that's causing issues in the neighborhood. And those are by and large located in commercial areas. It's the corner store that is located in a residential neighborhood that is causing the most issues for the residents.
Commissioner Thomas, this is Council President Galimi. Just to add to Councilman Moody and Beatrice's questions, just so we could be specific, would this, however, cause the Asian market on Bleecker, Rusnik, Annapolis, Bassones, would those then fall under there? Because I feel like some of those are definitely less than 6,000 square feet and do fit under these descriptions.
I would say yes, they would probably fall under this. Agreed.
So who would decide? That leads me to the question: who decides what stores fall under or do not fall under this neighborhood retail establishment?
In terms of who would this apply to and who makes that decision, it'd probably be a collective effort between codes and this office.
So there couldn't be any way where the council could decide these stores are neighborhood retail establishments and these stores are not neighborhood retail establishments.
I'm not sure I understood the question.
So is there any scenario where the council could say the following stores listed on the document are neighborhood retail stores, and thereby any store not on that list would not fall under this neighborhood retail establishment classification?
I think it'd be tough to pick a point in time and identify specific restaurants and list or specific establishments and list them by name because they just change so frequently. I don't see how you could do that within the legislation. Kate, you agree?
Yeah, I agree. It's really just about following the definition. So we would look at each, we'd look at each, the person who views it would look at each business and say, does it fit the definition of a neighborhood retail establishment as defined? Is it a retail business with less than 6,000 square feet of gross floor space? And is it selling dry goods and food and beverages, consumer goods and prepared food to be used and consumed primarily off the premises? If it's a deli that has 8 tables in there and people are in there eating lunch every day, it's a restaurant. If it's a store that is selling diapers and cleaning supplies and has less than 6,000 square feet, it's probably a neighborhood retail establishment.
And while Kay was talking, it occurred to me that I think somebody had mentioned a little earlier that some businesses will look for loopholes. If the legislation includes a list and their business name is on that list, they're just going to change their name, and now it no longer applies to them.
Absolutely. I see. That's a good point. I guess and we'll certainly move on, but I wanted to make sure of that because the real question in moving forward is so many people say, well, okay, we approach this legislation trying to be tough on corner stores, but it's, as a council, it's important for us to have a consciousness as to what stores might fall under this, because if we're trying to be tough on corner stores because we've seen articles where police have confiscated 45,000, all this illegal activity, but then we're not thinking about the other stores as well. To President Galimi's point, that might be impacted by this legislation as well. So it's good to know that those delis might be impacted as well. All right. Any other questions under this definitions from the council? All right. Certificate of use required. Any concern? That seems pretty straightforward. It's really saying in A, B, and C that in order for a business to operate, for an owner to operate that business, that they have to have a certificate.
So can I ask, Councilman Moody, may I ask this question?
Absolutely.
Presently, don't they have to have a certificate now to operate?
You have to have a business license through the county, I believe.
Okay. So they have to have nothing through the city. So what is the purpose of get a certificate from the city? What's the purpose of that?
Well, as I think you'll find in later sections, there's more teeth to this regulation, this permit, than we currently have over these kinds of stores. It requires background checks by the police department for the owner of the store. It also holds them to certain conduct, where if they don't follow that, they receive a certain number of points, and if after 2 years or 4 years they reach a certain number of conduct violations, they can have their certificate of use revoked.
Okay. So my view on that, and I'll wait till we get to that point. But my view on that is, if you are a store owner and you know that you have 3 strikes, what stops you from doing anything the first time? And the way I look at that is, if they do something wrong that's a flagrant felony, selling drugs, taking debit cards that they shouldn't be, there shouldn't be a second chance. You should be gone right off the bat. And then, I mean, because we go through this point system here, I mean, it doesn't really do it. It's going to take you 2 or 3 times to eliminate it. Where if they know there's a no strike rule, I mean, it's going to be a lot stricter. I mean, if we're really trying to crack down on things, then let's crack down on them. Let's don't just sugarcoat this and give them 3 chances. You got a store, you're doing something wrong, and you get caught, you should be done right then, or suspended for 6 months, or that's just my point. And maybe I'm wrong, but I'm just speaking my point.
I think the point system, Commissioner, the point system is kind of harder on certain activity, right? So if there are certain things that is found, that store, the city would have an ability to kind of take that license fairly quickly, right?
It's hard to hear you, Councilman. I didn't catch the last part of your question.
The point system is set up in a way that if that business is found, to have violated certain things, then the city can move more swiftly. And to Councilman Beatrice's point, that it doesn't have to wait, for certain percentages or certain points to take that business license away, right?
Well, there's certain points that are assigned to various infractions, and there's a certain amount of time in which those points accumulate. Keep in mind, to Councilman Beatrice's point, the city still has its nuisance abatement program, which can shut things down a whole lot quicker if there's, say, a no-knock search warrant executed and some criminal activity of a grave nature is found to be occurring there.
Okay, so let me ask you a question. Okay, So let's say that the store owner is found to be, and I'm not sure what the cards are called. The customer's going in with a card, and he's giving the store owner $200 in the card, and the store owner is giving the guy back $100, which we know this has been happening forever. That's a pretty flagrant thing. We're going to give that guy 3 chances before we could shut him down, or are we going to make it known that he should be shut down one time? Okay, because some of these rules, what we're trying to do, now we're lumping everybody into this. You have a place like Roma's and Napoli's and our big time businesses for our city that don't do anything like this, but they're getting lumped into this same type thing where all these stores are that we are trying to crack down on. Okay, so why should we give those people 3 chances? Okay, why? That's what, and I don't know exactly what the point system is, and to me, I'm not even going the drug route. I'm going stuff like that happens every day, and we all know what happens.
Councilman Moody, I thought we were going to go through this section by section. Now we're way ahead of where we
Okay.
were. I'm
I'm
really
sorry about
confused.
that.
We are going through it section by section. This question was brought up as a result of the certificate of use, so that's why
Right, but the whole point
question
thing is,
came up. But the point system is later on, so we will be moving forward. But it was a question based upon the certificate of use. Commissioner, do you have a response to that question? I know we'll be dealing with the point system later, but in terms of the use required.
Well, I was just looking at section 214.350, which talks about the point system, and it does mention that 4 points for some of the violations, such as welfare fraud and food stamp program fraud, which I think is more to what Councilman Beatrice is bringing up.
Okay.
Well, it does say 12 points or more within 12 months.
Well, I'll wait till we get to that point to go into detail there. The next section is section 214.339 application. I would like to read some of these entire because I think it's important. A says an application for a certificate of use shall be made by the owner or the proprietor to the Division of Code Enforcement on forms prescribed by the Director of Code Enforcement. The application shall request relevant information relating to the owner, proprietor, and the business to be conducted at the premises, including the existence of necessary licenses, permits for the business. Section B of that. Applications for the certificate of use are to be submitted by the owner proprietor, including a proprietor who does not yet own and or operate the subject business, but will own and operate the subject businesses within the next 90 days. Are we any questions about the first two? C, in the event the application is not approved, the owner and proprietor shall be advised as to the specific requirements which must be met to qualify for the certificate of use and the right to a hearing on such determination. D, in the event the Director of Code Enforcement determines after the city's review of the application pursuant to section 214.340 of this article that the business is not qualified for a certificate of use based upon any requirement which Director of Code Enforcement determines cannot be complied with by the means of an extension of time under section 214.342B of this article, the Director of Code Enforcement shall notify the owner and proprietor in writing of the reasons the application cannot be approved and provide notice to the owner and proprietor of the right to a hearing on such determination. Any such hearing shall be requested in writing to the Director of Code within 15 days of the date of such notice of determination. The application cannot be approved. Any questions regarding that? All right. E, a hearing when requested shall be held before a hearing officer chosen by the Director of Code Enforcement, who shall not be an employee of the Division of Code Enforcement, be recorded by a stenographer, take place no later than 15 days after the Director of Code Enforcement received the written request from the owner or proprietor for the hearing. The Director of Code Enforcement may adjourn the date only upon the owner or proprietor presenting compelling reason in writing to the adjournment of the hearing date is warranted. The owner and proprietor shall be allowed to be present, to be represented by counsel, and shall be allowed to call witnesses on their behalf and conduct cross-examination of all witnesses. Okay. Section F of that is upon the receipt of the transcript of the hearing, the corporation counsel or his or her designee shall have the transcript and all exhibits from the hearing forwarded to the hearing officer. The hearing officer shall review the transcript and exhibits of within 30 days of the receipt of the transcript and exhibits, render a written recommendation to the Director of Code Enforcement as to whether the application for certificate of use should be approved. And the next section talks about 30 days after the receiving, section G, 30 days after receiving the hearing officer a transcript of the suspension revocation hearing, all exhibits submitted to the hearing officer's written recommendation. The Director of Code Enforcement shall conduct a de novo review of the transcripts, all exhibits submitted at the hearing and the hearings officer's written recommendation. The Director shall determine whether the application for the certificate of use should be approved. If the determination of the Director of Code Enforcement is that the application be denied, the Director shall issue a written order containing his or her determination. Any such order issued pursuant to subsection G above shall be served on the owner proprietor pursuant to the provisions of Article 3 in the New York State Civil Practice Laws and Rules. Any council person have any concern, questions regarding the application process of these neighborhood convenience stores? Okay. Section 214.340, inspections and investigations. Any council persons have concerns about this? About section A of that? And I'll read it. Upon the receipt of an application for certificate of use, the Director of Code Enforcement or his or her designee, the Chief of Fire or his or her designee, the Zoning Administrator or his or her designee shall inspect the premises to determine whether the proprietor or owner are complying with the laws and ordinances which they are charged with enforcing. The Chief of Police and or his or her designee shall conduct a criminal background check on the applicant. The Chief of Police, the Director of Code Enforcement, the Chief of Fire and Zoning Administrator, along with members of their staff, shall have the right to enter any premises for which a certificate of use is sought for the purpose of making such an inspection during normal business hours, and shall also have the authority to seek warrants where necessary. Any concern or questions about that? My question is, does any other business license in the city of Utica the owners have to undergo criminal background checks?
No, this is the only one.
Now, currently, they
Oh, bars.
I think you went out, Councilman Beatrice.
Also, Beatrice, you muted yourself.
I'm actually muting quite a few people due to background noise so that everyone can hear everything on the call. So just remember to unmute yourself if you do have anything to say. Thank you.
Okay. So currently, right now, no one has to go through this, with the exception of somebody applying for a liquor license, I would assume, correct?
To my knowledge, that is correct. And the state actually handles the liquor license, not the city.
Okay.
Okay, to start this conversation, I don't think that I'm in favor of the Chief of Police or the city conducting a criminal background check on an applicant in concerning the corner stores for a license. I think that if no other business certificate of use operates in that way, I think it's unfair to require corner store owners to have a criminal background check. One, two, it should be predicated solely on the basis of their business activity and not on their personal, criminal record.
Okay. Mr. Chairman,
Yes, sir.
Mr. Chairman, this is your attorney,
Yes, sir.
and I would just like to say that I don't know what the source of this particular document is, but I do want to call your attention to section 214, 349, because this is where it supposedly you as councilmen are involved. Most of this, as you see, is done by other people. But if you look at section 214.39, they talk about suspension and revocation of a certificate of use. Are you council persons who are there are at that? See, one of the things of criticism, these pages should be numbered, because if you mix them up, you have to find out where they belong in succession. But section 249 says, they talk about the suspension and revocation, and in B1 says, a copy of the hearing notice shall be sent to the district counselor. Now, I assume when they say district counselor, the only district counselor I know of would be a council person. So they describe him as and then they go on to say that it will be the responsibility of the district counselor to provide notice of the hearing to his or her constituents that there's going to be a hearing. The district counselor is supposed to do that. And then in the event the district counselor and his or her constituents wish to provide testimony to be considered, and ultimately director of enforcement. In other words, I don't understand how you as councilmen have to send out notices of anything. And it doesn't say, who are you sending these notices to? Everybody in the district? How would you do that, number one? Financially, it would be a tremendous burden. And number two, it gets you involved in the suspension revocation process. Well, I find if I look at that particular provision, because that's the only place I see where you as council persons are being actively engaged. And I object to that engagement and as your attorney, because something's not something that Common Council wrote, somebody else wrote it. I don't know what the source of all of this is, because it puts a great deal of authority into the code commissioner. As a matter of fact, a hearing officer could hear the case and find there's no violation, and the codes commissioner can ignore that, which I find rather odd. But in any event, I'm not going to get into that. In other words, the Common Council did not draw this matter up. Somebody else did. But when they say that you are involved in doing some X, then I think it's incumbent upon me to bring that to your attention, because I don't think, quite frankly, that as council persons, you should be responsible to give anybody notice of anything. And as far as you will obviously be contacted by constituents anyway if this matter happens. But I don't want you to have a formal role in the suspension and revocation procedure or notice of the hearing of that. That's not your job. That should be the job of whoever thinks there should be a hearing of about a revocation or of the certification. Not you. And of course, you don't make any of these decisions. In fact, the hearing officer, everything is done by the codes enforcement officer. He appoints the hearing officer. And why should you be sending out notices? And who do you send them to? Some districts, like the 5th district that the chairman of this committee is a huge district. I don't know how many convenience stores there are in his location district, but I mean, it's a huge district. Who's he telling? And how far and close to the business?
Absolutely, Judge. Absolutely, Judge. I couldn't agree with you 1,000%. I agree with you 1,000%. And we're certainly going to get to that point because I think it is a point of concern. You bring up another point though that I was going to get to after my question was about the criminal background. It is about hearing, because I do think that it should be more inclusive in terms or more defined, that it is that the hearing officer is not just the choosing of the director of code enforcement, because I feel that can become muddy, and that a code enforcer can appoint a hearing officer in the future, if terms of accountability, can appoint somebody to approve any store that they want to be open, and also not approve any store that they don't want to be open in terms of the hearing. But I did put a question on the floor, not only to the commissioner, but more so to the members of the council, as to what are your thoughts about the criminal background for the owners. Now, I understand the intent of it, but I mean, asking anybody who wants to open up a store to submit to a criminal background check, I think it's unfair.
Councilman Moody. Yep.
I think I heard Councilman DeBringo, and then I'll go to council person friend.
I am in agreement with you. I don't think we should be doing the background checks. Certainly when they try to get a business license, aren't they checked at that moment if they're trying to operate a business, let's say sell liquor or to just open up a store, sell cigarettes? So I think at that point, I'm not 100% sure. I don't know if there are background checks done by the state when they do that. So I'm in agreement with Councilman Moody here. I don't think that we should get in the business of checking criminal background checks on the applicant. I think once they violate, maybe they are subject to a criminal background check once a violation occurs.
Right.
And then, they'll give us the okay to do it. But prior to it, I got to agree with Councilman Moody. That's all.
Yeah. Councilperson friend.
I would just like to second that. Councilman DeBrango is absolutely right. It just strikes me as inherently unfair and potentially very problematic in terms of who we're going to catch up here, so that anybody who's been convicted of a felony in the last 5 years for the sale of marijuana can't open a corner store anywhere in the city of Utica. That's unfair. We have a criminal justice system so that people can pay their debt to society. And then when they're done, when people have felony records, they get to do all sorts of things in this city. And I don't see any reason why they shouldn't also be allowed to open a corner store. But as Councilman DeBrango says, if they then violate certain laws while, through the use of their business, that's another matter. But the idea that in the past somehow they've been bad and they've been punished, and now we're not going to let them open a corner store is an incredibly dumb positive feedback loop that's just going to bite us in the butt. I'm done.
Councilman Moody.
Yes, sir.
I agree with Councilperson Friend and Councilman DeBrango and yourself. My other question would be, what do we do about the people, if you ever were to go this route, how about the people that already have stores that already have a record or have something on there, but they're currently opening a store and own a store. They've been a business owner for 5 or 6 years, and they are, a convicted felon, or we're going to tell them now that you can't run your store. We're going to shut you down. I mean, where are we going with it? I think you're opening a huge can of worms that I don't really believe is necessary. I believe, like the other council people stated, we have laws. When they go for a liquor license, they have to get checked through that. I'm sure there's loopholes, but I think this would be opening a huge can of worms. Thank you.
And Commissioner, before you respond to that question about really a grandfather question, and if stores are already open, would they have to submit to this criminal background check? is this application expected to be renewed? And in the renewal process of these applicants, would, let's say I had a criminal background check when I first applied. If I have to do this annually, would I have to submit to a criminal background check at every time that I submit this application?
Yes, the permit is renewable every 2 years. It is required that they renew. And I believe based on the wording of this ordinance, they would go through the background check every 2 years. Understand that too, that the next section, 2-14-341, spells out very specific infractions. So it's not your entire rap sheet. Thank you, Chris. It's very specific, and I believe they're identified specifically because of concerns of what these stores and their owners may get involved in. So it's limited to a very specific set of violations and convictions. However, this is up to the council, and we can certainly take that out if that's a concern.
Yeah, from hearing from I think that the application process and the criminal background check on the person, because as you know as well as I know, I mean, you could have a background check that's clean and still be in illegal activity, or be complacent with illegal activity that's happening in your store. And so I feel that that's a step that won't really necessarily crack down, on the issue. I think it should be based upon the point system. So I think that the council will make the recommendation that part be eliminated. Now, in terms of section E, in hearing, the hearing process, and the judge has pointed out a good point in terms of the appointment of the hearing officer. What are the thoughts of the council regarding that section?
Where are you now? E? Which E?
Yeah, 214-339 section E, right under the section that talks about the application.
Oh, okay, thank you.
It said section E1 says be held before a hearing officer chosen by the director of code enforcement, who shall not be an employee of the division of code enforcement. But in theory, that can be another person of the administration, right? Or city hall, or just not in codes, if I'm reading it correctly.
That is correct.
Now, are there other instances of a hearing officer in other parts of the city? I'm unfamiliar with this, where this is a similar setup. I mean, is it a similar setup where the head of that department can appoint their own hearing officer? I don't know what other board or department may have such a structure or need such a structure of hearings.
Councilman Moody, I just have to step away for 2 seconds, but I'm assuming you guys will be all right with this section on the screen for now. I'll be right back.
Yes.
To answer your question, Councilman, I'm not sure if there's other hearing officers. Again, as I mentioned earlier, this is similar to a nuisance abatement program,
Okay.
but unfortunately, I'm not involved with that process, so I'm not sure how that operates.
Is the council okay with this?
No, who pays for the stenographer? The city or yeah? I mean, they're pretty pricey, aren't they? I mean,
Right.
just a thought.
What,
Well, that's the reason for the $500 fee for the application. There are costs to the city, and that's what the application fee is intended to address is those costs.
Okay, thanks.
Councilman Beatrice, I think I heard you.
yes, this hearing that we're talking about, what would be the hearing for? If there's a problem, if they violated something, is that what we're talking about, or right from the beginning?
No, if the application is denied.
Okay,
Correct.
so if they go for an application and it's denied, okay.
Question.
Yes, sir.
Yeah, so I'm not sure if you got this. I've been in and out because I was on the road, but now I'm back. So when a convenience store goes in on the corner, how many feet does another convenience store I mean, how much is it? Are we going underneath the guidelines of 1,000 feet like we did in that master plan? Or is that just a $200,000 BS job?
I don't think
We're
we got to that point, Councilman. And really, I don't see
Well, an
well,
application. I'm talking about the application to open up a store. We're kind of in that area, and we're looking at a application, $500 to open the store and do background checks and everything else. But how close can they be to another store of that similar thing?
Councilman, if I can address that, under our proposed zoning ordinance and zoning map, we're eliminating that requirement. That's one of the requirements that we found. We tried to use that in zoning to address convenience stores, and we have found that not to be effective. And what we're proposing to replace it with is this permit process.
So what I'm getting at, so you have the one on Oneida Square, and then right across the street, you have another one right across, within 25 feet of the other store, you got another convenience store. And then if you go to the right, you got another convenience store.
Yep.
So I'm just curious, when that going to be held accountable, or is that, I mean, that's what I'm saying. That's where you come in, the zoning piece of it. But who authorized that zoning anyways, even if it was against the rules in the first place?
Well, it wasn't against the rules. That is our current rule, the 1,000 linear feet. However, it's possible to get an area variance through the Zoning Board of Appeals for that, and that's the zoning board granted the variance, and that's what allowed at least one or two of those to open.
So basically, the zoning board allowed and went against their own policy. So I think it's very so really, you all can't make the claim that it's not effective if you, as the zoning board, overturn your own policy.
But they weren't overturning. They were within the variance. They reviewed the variance, and they were well within their rights to grant the variance. It's part of the legal powers and authority of the Zoning Board of Appeals.
No, I get the legal authority, but to make a statement that it's not effective, to Councilman Williamson's point, I do agree that in the same way. I remember when I believe it was Marino at the time when he was on the board, or whoever suggested the you can't have a liquor store within a certain square feet. I think, to Councilman Williamson's point, I think that is a good ordinance to maintain, and we'll be dealing with the ordinance code later on, but to keep on the books in terms of square feet. But it's not in this particular ordinance, Councilman, in terms of the square footage.
Hey.
I don't know if you were saying something. You muted yourself.
Yeah, no, I muted myself. I don't want no background noise. But
Okay.
Yeah, I'm fine. I'm just pressing along, so I'm trying to catch up and stuff.
Right. Okay. All right. So in terms of the hearing, the hearing officer chosen by the Director of Code Enforcement, any other thoughts on that part?
Yes, Delvin, just getting back to this same thing with the hearing part. So what's the solution to the people that already have the stores? Where are we with that? Is there a possibility that somebody has a store, been operating for, let's say, 5 years, and now he has to apply for a permit and he gets turned down? Is that possible to happen?
Absolutely.
Okay. Thank you.
And then if they're turned down, they go through this hearing process.
Okay.
And they are subject to pay a $500 fee and to renew?
Yes.
Okay.
So the council's okay with the Director of Code Enforcement appointing this hearing officer? Because that's the big question, because I think that'll come up later.
I can't speak for everybody else, but there's a lot of this stuff in here that I'm not good with at all. So I'm listening and I'm taking in, and we'll make notes on it.
All right, going down to, if everyone's okay, inspections and investigations. Upon receipt of an application, certificate of use, the director, his or her designee. So that I read that, but that's the section that of the composition of who investigates the stores. Okay. It says director of code, the zoning administrator, the chief of police, and the chief of fire can expect any property during normal business hours that submitted an application. And they said the
Without a
director,
warrant.
you're right, without a warrant. And I presume that's all legal.
I'd like to ask a question about that. So people don't have a store, they have to apply for this license in order to open a store. So this would really only apply when people are applying for their recertification, correct?
I believe earlier, if I can find the section, 214-339B, I believe. Applications are to be submitted by the owner or proprietor, including a proprietor who does not yet own or operate the subject business, but will own or operate the subject business within the next 90 days, which means they'd already have a location selected.
Okay. So we can go in and inspect the prospective business in advance of them opening.
Correct.
That's all we mean. Okay, thank you.
Okay. And I think we want that from Section 8 that the chief of police will conduct a criminal background check on the applicant. I think we're at 214-341, insurance and issuance of certificates of use and conditional certificates of use. A certificate of use shall be issued when the following conditions have been satisfied, all fees paid, the application form has been completed and accepted by the Division of Code. The owner and proprietor have all necessary license and permits, and the proprietor does not have an expired conditional certificate of use, a certificate of use, or conditional certificate of use that is under suspension. 5 is doesn't owe the city any money. It says the owner and the proprietor do not owe the city any money for delinquent taxes, water charges, civil penalties, parking tickets, or other duly incurred charges, fines, and penalties. 6, due to the interaction between proprietors, which is explaining 5 again, has an interest in protecting the health, safety, welfare of the public. City will conduct a criminal background check. This is the section 2. Accordingly, the city will conduct a criminal background check on each applicant in accordance with section 29616 of the New York State Executive Law. The Director of Code Enforcement makes a determination in accordance with Article 23A of New York State Correction Law. Specifically, the criminal background check shall initially be reviewed by an individual who is not directly involved in the final determination. For purposes of this paragraph, this individual shall be called a screener. The screener shall review the criminal background check and determine if the applicant is convicted of the following. Now, before we get to that, who decides who the screener is?
It doesn't necessarily say within there. That's a good point.
Can I would just like to suggest this entire section 6, A through G, all of it, I'm not going to be comfortable voting for this if any of that is there. I'm not comfortable with the whole criminal background check and the idea that people who have been convicted of felonies, done their time, are now no longer welcome to operate a business in the city. So this whole section, I'm not going to be comfortable voting for anything that has anything like that in it.
I agree with Councilperson Friend on that.
Yeah. All right. So that as you said, the whole section 6 is really in connection to the background check.
I have something though.
Yes, sir.
So if someone gets in trouble, they get sent to jail or something, like somebody who's a sexual predator or something like that, now he's going to be held accountable for the rest of his life, right? It doesn't go away. So I think it's a case-by-case basis what they did, first of all. So I think you should leave it in there to a certain point. But, I mean, there's got to be some checks and balances, especially if the guy has the history. So if you got a sexual predator and he opens up a candy store for kids, how's that look? I'm just asking the question.
Yeah, but Mark, I agree with you 100% on that part of it. But most of these stores where these people are opening businesses where the problems are, they sell alcohol. And for them to go through and get alcohol, if they have that kind of stuff and that record and that stuff, they're not going to get that. They're not going to get that license and be able to open the store anyways.
True. Okay.
That's my whole point. We've been operating for 1,000 years without any of this, and obviously there's got to be some problems with why we're bringing it here. But the state, they have to get licenses through the state. They have to get resale certificates. They have to go through the state and all this stuff. Why are we getting involved in this now? That's what I don't understand. I mean, to me, and we'll get to it's a very simple solution on how to take care of the problem we're having in these stores. And when we get to that point, I'll give you my ideas on it. But I mean, the rest of this is to me, you're invading a person's privacy. I mean, on all of it. I mean, I do agree with what you just said on that part of it when you bring that extreme to it. But I think the other end of it is more alcohol, selling drugs, welfare fraud. I think that's where our problems lie. And again, I don't think they should have 3 or 4 chances. I think if they're doing major things like that, you got to go. We don't need to have 3 chances. If you're playing baseball and you got 3 strikes, you're going to swing at the bad one the first time, the second time. Okay? You shouldn't have 3 strikes when it comes to this policy. That's it. So I'm sorry I got involved again, but I'm just telling you how I feel, you know.
I would leave it in there and I would put an amendment to it just to put clarification on it and talk to the judge and everything. So,
Right.
You're right.
Okay.
Okay, so the question is about the criminal background check, and I guess that just would be, I guess it would just need more conversation amongst the council in terms of the background check. Now, we did say earlier that it could be done as, like, I don't want to say punishment, but as a response if we see criminal activity at the store. But I think that kind of gets back to the same point of criminal background checks in general. And or should we be just focusing on the activity of the business itself, which might be criminal, so maybe the language can be something like, if there has been illegal activity in response to the operation of the business, not of the person, right? Then that would prompt the city to do a criminal background check maybe at that moment, because
Right. They would be subject to a criminal background, and that would be on the application.
Right.
So they're reading it, they're signing it. If they did something wrong, you're going to be subject to a background check.
Right. But based upon the business activity. Now, 7 is talking about section 7 of number 7 of this section here. Is it 7? I think I lost my part B talks about this conditional license. My question to the commissioner is, in what instance would a conditional license be then issued?
If there's instances, say, if there's things found during the inspection of the premises, such as they need to bring something up to code, or they need additional fire extinguishers, for instance.
Those type of things.
Something that can be fixed in a set amount of time in order to bring them into full compliance. This allows for the code commissioner to issue a conditional certificate of use and set a period of time by which those items must be addressed in order to receive the full certificate of use.
Okay. Any questions there from the council? And of course, it has the language of the background checks in that. I think that just is going to need more conversation amongst the council. All right. 7 deals with the signing, the notarization of all of that. Section C, well, letter C, your letter C of that talks about the proper dating of that, the completion of the requirements, all deals with the conditional license of the operation. Everyone good with that? Okay. Section 214.342, operation of the business. The proprietor of any business shall comply with all provisions of federal, state statutes and rules and regulations of the city of Utica local laws, ordinances, rules, and regulations relating to the conduct of businesses and occupation, use and maintenance of the premises in which the business is located. Moreover, owners and proprietors shall comply with any and all notices, orders, decisions, and determinations made by any city official which governs the occupation and use of the business. Section B is talking about shall cause the certificate of use to be posted in a conspicuous place visible to the public and premises of the businesses. C, the proprietor of any business shall not permit at any time a greater number of persons on the premises. The proprietor of any business shall maintain good order on or about the premises at all times. The proprietor of any business shall also be responsible for removing refuse from the premises and obstructions from the sidewalk adjacent to the premises, as well as for operating the business in accordance with the requirements of all state statutes, rules, and regulations, and all city of Utica local laws, ordinances, and rules and regulations, and for operating the businesses so that neither the business nor its patrons become a source of disruption to other building tenants or a source of disruption on the sidewalk, streets, or private property in the vicinity of the business. The term failure to maintain good order shall include but not be limited to the following. Now, before we even get to that part, I walk through Oneida Square and ride through Oneida Square every day. And when we talk about the issues in Oneida Square, the police officers say that they can't ticket for loitering, right? For people just hanging around, they have a constitutional right. Would this be an argument, right? And maybe Corporation Counsel can argue this, or maybe you all can argue this. Is this an argument that you're asking business owners to get in confrontation with the public? Now, it's one thing to say to maintain good public order, right? But I think to be real about it, I want to see you as a business owner tell folks in Oneida Square to move, and they comply with that. So is that, I understand the intent, but is that kind of a heavier burden to place upon the business owner to have that, or should that be, a strike against them if they can't necessarily make people outside their business comply with that particular rule and regulation?
I think every business is different, and but that goes down to what time do they close at night. I think you got a lot of loitering down there during the daytime, but they'll move along. The problem is with the police is later at night when it's dark and you got all kinds of people hanging around, and then they're staying, the store's staying open to midnight, 1, 2 o'clock in the morning. You know as well as I do, nothing good happens after midnight, and
right.
And so the loitering becomes more of a problem because there's other issues going on. I think during the daytime, Bob Darley would move people along and
Right.
out in front of the thing, and then of course they trash his windows the next that night. And but that goes for anything, just like the pizza place there. I'm sure they move people out of there. You can't loiter around the building. So I think, but during the nighttime, that's where the problem's going to be. And that's why we got to put a nice time on this when they have to shut down, not, midnight, all that good stuff.
Mr. Chairman, I have a question for the Corporation Counsel.
Yes, sir.
Corporation Counsel, is there any way that the city could implement the signs like no loitering, or you will be fined, or things of that nature? Is there a law that we can do something like that where at least it'll protect the police officer if he has to come upon somebody and they've been hanging around there for an hour, 2 hours, 3 hours, whatever they've been doing? Would that help? I don't know. It's just a question.
Councilman, that's something I'd like to discuss with the police. I wasn't really aware that the police weren't enforcing the loitering law. That's kind of news to me. I know that there are certain laws that are on the books that the police can't enforce, like there are certain laws against like panhandling, which can't be enforced. But loitering, I would want to talk to the police about that and what the limits of their enforcement are before I could state whether we would want to or be able to put up a sign. But I will find out about that.
That's important because they tell us, well, they have told me that they cannot ticket for loitering.
Okay.
That it is unconstitutional because you cannot tell a person on public property that they cannot be there.
Yeah, can I just add, I've always understood or long understood anti-loitering laws are unconstitutional. You just can't tell people that they can't hang out on public property.
Right. I agree with that, Councilwoman. But I mean, to the extent that people are hanging out in the doorways of stores and stuff like that, and if that's being tolerated, if it's on private property, I think that might be a concern if business owners are allowing people to kind of loiter within the store or within the threshold of a store. That could be something that maybe the onus should be on the store owner to make sure that people aren't congregating unnecessarily within their stores or within the thresholds to their stores.
Right. So I have just a general question about this whole section, and I think it's very similar to something that Delvin was saying a moment ago. Could you be quiet for a second? Which is, it seems to me that we're asking the store owners to become the law enforcement here, like prostitution and food stamp or welfare fraud and possession, use, gift, sale, illegal drugs. I mean, I get what we're trying to do, but I don't know that it's feasible to expect people who own stores, or let's even just look at, well, there was one of them was just littering, number 7, littering. So we're going to make it the responsibility of a store owner to enforce the law against littering. And if they don't enforce the law again, if they don't succeed in enforcing the law against littering, we might take their ability to operate their business away. That just seems very odd to me. It seems a very odd division of labor in the world that we would expect private business owners to be enforcing the law on public property, the sidewalks in front of their stores.
Well, I have a comment on that. If you go by those stores, there is a numerous amount of trash that are on the sidewalks. And
Right.
it shouldn't take much for the manager of the store to go out there with a little sweeper and clean up in front of his storefront. It's only proper that you do that. The one thing the one thing that I'm concerned about is I had some complaints that they leave trash bags. They just leave bags of trash right there front and center or on the side of the store, wherever it may be. And it's just there for days and days. And the odor and the rodents and things of that nature. I would suggest that we come up with some sort of trash containers or something they could put it in, and then the city would pick it up on their trash night. But they should be able to secure something, at least just to keep it neat and clean. But I've had complaints on Eagle Street. There was a store on Eagle Street, and the papers would blow from in front of the store down in front of a gentleman's residence and end up cleaning it up most of the time. And they just don't maintain the front of the store. I mean, they should just take a walk out there, clean it up, make sure there is a trash bin out there so the members could use it. If they don't have a trash bin out there, a young kid comes in, gets his ice cream pop, walks away, throws the paper on the floor, on the ground, and off he goes. So I think they should have trash containers. I think they should have just for the trash that is accumulated over the week's time, big containers, and then the small ones that when you're buying something, if you're unwrapping it, at least they could at least try to put it in the container. So I think that they should maintain their storefront property. That's my opinion.
That's a good idea, like Gran Torino, right? Get off my lawn, right?
May I respond to Councilwoman Friend?
Absolutely.
So I know it seems a little odd that it seems like we're asking the store owners to be the enforcers, but there's actually precedent for this in other laws that the city uses all the time, like the nuisance abatement law, where we put the onus on property owners to not condone or suffer the unlawful activity of their tenants. And we would be treating store owners similarly here. they should not be creating an environment where they will suffer or condone or otherwise just sort of suborn bad behavior or, on the part of their patrons, so that they aren't allowing things to breach into areas of illegal activity. If a store owner doesn't make clear to the people that patronize the store that that won't be tolerated, then they are at fault.
Right.
And that is what this law takes into consideration.
But it's one thing if you are a landlord and you allow illegal activity in the apartment that you are a landlord of, then to require a store or say that there's a failure to maintain good order for things such as prostitution. For example, I'll give this. Okay, so in Oneida Square, you have those corner stores, and we're all thinking about that. But right behind one of those corner stores on the Genesee Street side, there is Mikasa. Mikasa is I mean, I talked to them and they are very upset by the prostitution that is happening above their restaurant and on the back of their restaurant in Oneida Square. Now, are you going to put on Mikasa the failure to maintain good order? They would very much want it not to be prostitution above and behind them as any other business owner. So to me, it's one thing with the nuisance and abatement where you have landlords that just don't care as long as they get their rent at the beginning of the month. Then for the store owner to have the expectation to in some way enforce the law in front of their store. I don't think that this is a huge component of it, of the overall ordinance, but to me it gave me some pause in reading it.
Can I break in there? I just want to know what it looks like when a store owner does the right thing and tries to stop prostitution taking place around their store. Because I'm not picturing what that looks like. And I think that goes to Mr. Moody's example of Mikasa.
So I think obviously a store owner can't do anything about a prostitute that walks in front of their store or stands on the sidewalk in front of their store or on a corner near their store. But what a store owner can do is not allow people to loiter in their store that might be committing prostitution, that might be trying to solicit customers in their store, that might be hanging out in the store and talking to people in an attempt to solicit them. I think that, obviously it's going to be sort of fact specific if there is an accusation that, leads to a possibility of points. But I don't think we're attempting to make store owners responsible for something that has nothing to do with their store and only has to do with the general location they're in. There has to be a relationship to the way the store is being operated and what is being tolerated on the premises.
Okay.
On and about the premises. It does say on and about the premises. Maybe that's a vagueness there that is part of the problem.
Yeah, I think that it could be reasonable to just say on the premises to clarify that. And I think that would protect the store owners while still making them responsible for what happens in their store. But remember, frequently the store owner owns all the way to the middle of the street and the city just has a right of way. So they still own property. They still own the property and they can still tell somebody to get off of their property. So I would just add that in as well.
Okay.
Can I tell somebody to get off my sidewalk? This is a genuine question.
I think under certain circumstances you can tell people to get off of the sidewalk. Yes.
Okay. That'll be the urban version of get off my lawn. Okay, thank you.
Off my lawn, yes.
Okay, I want to move to if everyone's good with that. Legal hours of operation, is that defined? Is that are there legal hours? It could just be a novice question, but are there legal hours of operation currently?
Where is that?
11.
No, thank you.
D11. Are there legal hours of operation currently in the city of Utica?
We do not have set legal hours of operation for these businesses or any other businesses, I don't believe.
Okay.
then what does 11 refer to?
Future legal hours of operation, Councilman Williamson would
Clocks.
say.
I believe it may be what they specify within their application.
Okay.
Because they will be approved for the plan they present. If they get approved, they'll be approved for the plan they present in their application. So if they state in their application that their operating hours are going to be from 9 in the morning until 9 at night, those would be their legal hours of operation.
Okay. All right.
Okay.
Section
Look,
2.
Hello, Delvin.
Yes, yes.
Okay, this is Councilman Beatrice, and this is one point that I wanted to speak to.
Mhm.
As far as 11 o'clock goes, I truly believe, and you guys, I think this is where the problem lies. The problem lies that after dark and people are hanging around these corners and most of these stores is where the problem is. In my opinion, and we could talk about it after, I think there should be a 10 o'clock cutoff for all these inner city stores. That's it. Not inner city, for all this type store. Unless they sell gas, they should be 10 o'clock, they should be shut down. You would eliminate all this stuff that we've gone through for the last hour. 75% of it, you would take care of that by shutting the stores down at 10 o'clock.
Is the chief of police there now? Is there a police department there in the meeting?
No, there is not actually, unless they're with you, Brian.
Is codes on too? In addition to that, is codes on?
Codes is not on. No.
I talked to the chief offline about this a couple weeks ago. Most of their problems are in the evening, 11, 12, 1 o'clock, 2 o'clock in the morning at these stores.
Mm-hmm.
Like I agree with what Beatrice says. As long as they have gas pumps, which there's fast tracks all over the place. There's one down by Olveston. They got gas pumps. They can stay up. They can stay up later.
My problem with that is that you could potentially limit economic development, in my opinion, if there's a proper store who wants to operate legally. Now, for example, let's say I want to open up a corner store near Utica College, near MVCC, near, or even in Oneida Square, and let's say 5 years from now we clean up Oneida Square, and that's a place where college students want to go. If I'm open, if I'm a legitimate business and I'm open till midnight, maybe on the weekends, I could see a scenario where that's beneficial to college students.
I agree with you. Let me ask you this question. Wouldn't it be possible, the way they've talked about other scenarios, wouldn't it be possible when they went in front of a zoning board and maybe had a restaurant ordinance? I believe one of the attorneys spoke that if they were open and they had 8 tables, they would fall under a restaurant instead of a bodega store, so it wouldn't really fall under that. I mean, it's just a thought, but I'm just, we're all on here. We know where the bulk of the problem is,
Right.
and that would solve a lot of the problem. Again, it's just my opinion, and that's all I can say on that. But I do agree with you, Delvin. You are right, because there is certain areas where somebody could open a store for takeout, and it would hurt them, but. The high percentage of it, that would help the situation.
Yes, a corporation counsel or commissioner, let's say, now, of course, it's not in this ordinance, but let's say there is something to consider later on that Councilman Beatrice and Councilman Williamson said, we want to make sure corner stores close at 11 or 10 o'clock. But if a corner store wanted to make the application to the board to say we want to stay open until midnight or 1 near a college town on the weekends, would that be a possibility?
That would be a possibility. I think you just have to maybe amend it into this law and then decide what board it would go before, and there'd have to be certain criteria upon which granting that application would be based.
Okay.
Yep.
All right. Yep, I agree.
All right. 214-343 talks about fees. It says the fee for the certificate of youth, both the initial for the certificate and the renewal, shall be $500 every 2 years. I know that there was some concern about that.
Okay, can I speak to this point? So
Yes, sir.
here's my thought on this, and I do understand what Mr. Thomas spoke of before, the filing fee, and they would pay all that stuff. Here's the problem I have with this. Okay, so it's $250. What's $250?
500 every 2 years. Well, yeah, that'd be 250.
Yeah, 250 a year. Okay, so and again, the bulk of the stores, okay, the places that are having a problem, okay, our problem stores, they can make one transaction, two transactions in the back of the store. They make their $500. It's nothing to them, okay? They don't care. But the people that are running a legitimate store and are doing, the right things, I got a hard time I got a hard time charging people who are trying to make money in our city and to do this. I really do. And, again, it's just how I feel about it. I just feel where we have the bulk of the problem, this $500, that's nothing for them to pay. But for the other guy who's legit and doing what he's supposed to be doing and running everything, $500 is a little bit steep just to get a permit every 2 years.
Councilman Beatrice is absolutely right. I went and talked to the people at Ridgewood Deli, and they found, in my ward, and they thought $500 every 2 years was very steep. And Mr. Beatrice is absolutely right. This will be nothing to the people who are actually trying to clamp down on.
No, I disagree. I think $500 isn't enough, but that's just me.
Mr. Chairman, could I weigh in for a second?
Absolutely.
If we reduce the fee, whatever we reduce it to, but if if there's a violation, they should be subject to pay a fine for the violation. So anyone that's running the legitimate stores, and they're doing fine, there's no problem. They're not going to have to pay anything. But the people that are running the stores that are doing some illegal activity, it'll add up to maybe $500 in 1 year. You know what I'm saying? So I think the fines shall be increased, and maybe not the initial application fee.
That's a great idea. That's a great idea.
I agree.
Like I said, this whole thing, I have no problem. We should have the right to go into these stores, inspect them, see what they're doing, make sure they're following the rules. And if they're not, we need to have our people, whoever, I assume it's codes that goes in there, crack these people and not only fine them, but we need to follow up to make sure they pay them. That's when you need to, if they're not paid within a certain amount of time, close their doors. That's the kind of stuff that we need to do. We need to enforce these rules. It's very easy to put this legislation down, say you're going to pass it, and then, stuff doesn't get done. I mean, there's probably a lot of these stores that are not up to compliance, where we can make a lot more than $500 in 2 years off them. So I'm in favor of no fee in the beginning and just enforce the fines. That's what I would like to see.
Maybe Corporation Counsel can speak to this because we don't have codes, and I hate to put you on the spot, but we don't have a codes officer here. With these, we've seen in the paper, right, that 45,000 selling the K2, all of that stuff, and they're open. They were open the next day. So with these codes, we see trash on the street, in Oneida Square and other places. I mean, there has to be code violations. That's the first thing. Are the codes officers there given these violations, and how are they able to stay open under the law currently?
So, codes violations, it depends on the type of codes violation. So litter is one type of codes violation that doesn't really go to the safety or, habitability of the building. So there are certain codes violations that have to be pursued in such a way that the building could be closed down or should be closed down for safety reasons. And there are other codes violations that are just really the only cure is fines. I know that our codes department enforces all of the codes very diligently, and they, you know, make inspections, and they do everything they're supposed to do. If you have particular codes concerns, I would recommend that you speak with the codes commissioner, who can probably better explain, you know, what they're doing to, you know, enforce among convenience stores.
Okay, Commissioner, is it possible to put in this when you probably when you resubmit it to the council, or either we can make the amendment on the floor? But is it possible for you to put in here a fee structure that is contingent upon the violation?
Is it? I have another question as well.
Yeah, I'm not sure how to address that, because most of the, correct me if I'm wrong, Kate, but most codes violations are taken through city court, in which case they're given a small paltry fine, and they just pay the fine and move on.
Yeah, so part of it is we don't keep all of the money that's collected in codes court. I'm not sure what the breakdown is, but the other thing is that there should be a fee associated with getting a license, because it costs money to administer the program, even if people aren't committing any violations of codes.
I agree with that, and if you do, let's say it's $250 for 2 years or 200. That with that though, you would get at least one inspection each year at no cost, no charge. So I think we could build it into at least you get an inspection for the first year, and you get an inspection for the second year. It's going to cost you $250 for whatever it may be. But
sorry, Frank, I want to just throw something in there. This is Galimi. The issue with the fee, though, legitimately, I understand that fees pay for the service, et cetera, et cetera. We're going to be applying this to 97% of the people that we apply this to are not the people we're trying to shut down. Just throw that out. Just think about that for a minute. That's the issue with the fee.
Yeah, I agree. Kate, can I ask you a question, Kate?
Of course.
Okay, so I know what dealing with Marcus in codes, and he explained to me about the abatement process where he goes to these peoples and say, I have a place right now in East Utica that's a problem. He went there, he gave them a ticket, they didn't do anything, so now he calls either Parks or DPW comes, and it's the same thing they do with High Grass. They come, they clean it up, and it gets added, it gets charged, and it gets added to his tax bill.
Yeah.
Okay. Okay. So why couldn't we do something like that with this?
Well, you know, I don't think that it would be like a legal impossibility to do that. I think we would have to do some rewriting, and we'd have to be very specific about, you know, for what? Because if there's codes violations, they're already eligible to be abated under that law and put on the taxes. I don't know that we'd need specifically anything new if there's codes violations at a convenience store and and we have to abate them. Maybe the law we have already applies, is what I'm saying.
No, what I'm trying to say is if we go into the place and we catch the person doing something and he's got a $500 fine and he does not pay his $500 fine, okay? Is it possible?
I don't think we could do that. No.
Okay. All right.
It's a different thing if we're performing a service that they have to perform to maintain like the safety and welfare, but we cannot put city codes fines on somebody as a lien against somebody's property. We can't.
Right. So they would be, so basically a lot of it, like we talked about with garbage in front and all that, is already a code. It's already something that's in place right now. So if they didn't come and pick it up, we'd come and pick it up. And that would get charged to their tax bill. So it's basically already there.
Yes.
Okay.
But hold on. We can't say, if we pass ordinance 10, we can't give them a fine for breaking ordinance 10 or section 214, whatever, you know. We couldn't give them a fine for breaking this ordinance. Codes couldn't enforce that.
We could give them a fine for operating a business without being licensed pursuant to the ordinance, but it's not something that we could add to a tax bill.
And there's already a fine in here within this legislation. It's in one of the later sections, penalties, criminal and civil. The second to last section, 214-356, for just what Kate mentioned, operating without having a valid certificate of use in place.
Yeah.
Also, Kate, when it's adding it to the tax bill, will go to the owner of the property rather than the owner of the business.
Oh,
Well, that's
okay.
true, but
Yeah,
in the case of
that's right.
codes, you know, that is because an owner of the property, you know, is the one who's ultimately responsible for what happens on that property. So, and this law also contemplates, to a certain extent, the difference between an owner and proprietor, and I believe calls for both of them to apply and be licensed. So,
Right.
so yeah. So just to be clear, though, we aren't going to be able to put an unpaid fine on somebody's tax bill. When somebody doesn't pay a codes fine for something that isn't like an abatement situation, a bench warrant goes out for them. That's the next level of remedy. So,
But also too, they wouldn't be able to renew their license unless that was paid.
that's absolutely correct.
Right. Okay, I think I want to move on to section 214.
Councilman, if I could just go back for just 1 second.
Yes.
If the intent by the council as a whole is to lower the permit fee, the application fee, keep in mind that the part of the process includes, and part of the expense to the city is the background check. And if the council is looking to eliminate that as part of the application process, then that reduces the city's cost. So you could reduce the application fee through that method as well.
But when right, but President Galimi said something, and I don't know. I don't. He said that 97% of the stores who would be infected by this are not the stores in which we're trying to.
That was a matter of speaking percentage.
No. I know.
Calculated.
I get that, but I don't actually think that's the case if this definition is as tight as I think we all think it to be. I do think that the definition is crafted in a way where the majority of the delis and stuff are really not in this, at least as Commissioner, I might be wrong, but I think that you actually crafted the definition in a way that we're kind of going after who we want to go after.
Yes, we spent a lot of time on that.
Yeah. Okay, so 214, 344, I'm going to go back to how I was doing it. Are there any concerns of the council about the expiration of the certificate? Okay. 214, 345, any concerns of the council regarding the renewal of the certificate? Pretty straightforward. And 214, 346, the transfer of the certificate. I do think, though, this is important because the activity, maybe the commissioner can speak to this, but if you can speak to this particular part of how sometimes owners or proprietors would transfer certificates as a way of a loophole to maintain the business, even though, you know, they're not the particular owner at that time. Like they're transferred to a cousin or something like that, if I'm not mistaken.
Yeah, a lot of times the zoning board, when they're looking at certain variances, will tie the variance to a specific owner. That's similar to what we're trying to do here. We just didn't want them to change owner or change proprietor and think that they didn't still have to
apply,
have a certificate of use in standing.
Right.
So any change in the ownership or the management of the store, the proprietorship, requires a new application.
Okay. Right. All right. Section 214, 347, failure to apply for a certificate of use. Everyone good there? Section 214, 348, operation of business. The proprietor or owner of a business subject to the provisions of this article must obtain a certificate of use or conditional certificate of use prior to the commencement of any business operation. In the event any application is approved, the Director of Code Enforcement shall issue the proprietor a certificate of use in accordance with the terms of this article. In the event the application is denied, the provisions section 214, 339 shall be followed. Okay. All right. Suspension and revocation of certificate of use. The judge, our counsel a lawyer, did bring up the part about the members of the Common Council being responsible. I believe it's in this section. Be responsible for the noticing of hearing. So I'll start with Section A. Certificate of use conditional issued pursuant to the article may be suspended or revoked by the Director of Codes in accordance with the provisions of this article based upon findings after a suspension or revocation hearing on notice conducted in accordance with the procedure detailed in subsection B below, a closing of the business location pursuant to Section 214.346C, failure to comply with the provisions of Section 214.350, and the proprietor or owner has been convicted of a felony or misdemeanor involving theft or fraud since the certificate of use was issued as detailed in Section 214.349C below. Is everyone okay with that? Okay. Now, Section B talks about the copy of hearing notice shall be sent to the district counselor in whose district the subject is located. It shall be the responsibility of the district counselor to provide notice to the hearing to his or her constituents. And Section B said in the event the district counselor and or his or her constituents wish to provide testimony to be considered by the hearing officer and ultimately the director of code enforcement, they shall be allowed to submit written statements under penalty of perjury, etc., talking about all of that. Now, do council, I certainly have concern with that. Do any of the council members want to speak to that point?
Mr. Chairman, as the council attorney, I don't see where it's our responsibility to provide notice of a hearing to anybody. I don't see where the councilman should be involved in the distribution or any of the acts in this matter. I think it should be an executive matter done by executive officers, and that action should be reviewable. And I don't see the purpose of A and B. I see the purpose of having people present at a hearing about revocation and notice and all that, but I don't see how it gets to the council level.
If I can address that.
You have 15,000 constituents in the 5th district.
Yeah.
Who are you notifying? That's, so I don't understand that at all. I don't know where that provision came from, but I strongly urge you not to allow that to remain in this law.
Commissioner, is the intent to provide constituents around that store the opportunity to have testimony in the hearing?
Exactly. I think you all know about the 200-foot radius that we have that's at issue with the zoning board, and whether that's too far or not far enough. In some cases, it could be one or the other. This handles it a bit differently, this language here before you, in that it's an optional notice. It's not a required notice, but it leaves it up to the council person to determine how far they notify property owners around that particular store that's having the hearing. And it leaves it up to that council person whether they want to notify their entire council, their district, or nobody in the district, or just a few houses within the district. It leaves it up to the council person. It's taking it off the city and some arbitrary radius around the subject property. And I think it's actually a pretty creative way to address it as opposed to what we currently have with the zoning board. Council person. And I think it addresses some of the issues that several council people have suggested as changes to our current method. So I'm not sure why there's issues with it. I would think it would.
I have to totally
embrace.
Mr. Thomas, on judicial review, everything that isn't done pursuant to a piece of legislation is subject to judicial review. And it's also subject to hearing officer review about who is notified and all of that. You're putting all that burden on the common council. I'm saying the common council has nothing to do with that. Not at all.
It's optional.
It isn't optional. It says we shall, it copies, it shall be the responsibility of the district council. That isn't optional.
It's saying that the city isn't going to notify anybody.
Yeah, well,
I'm saying that that's your responsibility. How you want to notify anybody about this hearing about revocation of the use is your business. It's not the business of the common council. No, nor is any zoning notification the business of the common council. It's done pursuant to zoning ordinance. How you do it is your business. It's not the common council's business. That's all I'm saying to you. And that's
I
my
would suggest the common
responsibility.
council has insisted that it is their business.
If you want to be argumentative, Mr. Thomas, you can do what you want. I advise the common council, and they can do whatever they wish with any provision they want. There are so many things that I could say in this matter I do not wish to say because I didn't draw it, and I think it will be under judicial review anyway at some point anyway, and that is not for me to judge at this point. But when you involve the members of the common council, that is my business. And that's all I will say about that.
Yes,
sir. And I don't want to argue with you, Mr. Thomas, about that point.
I think Councilman Beatrice.
I have nothing else to contribute to that.
I think Councilman Beatrice wanted the floor.
No, the judge said everything that I wanted to say. Well, I'm all set. Thank you.
First of all, the individual council person doesn't have a budget at all. We have no discretionary funding. We get, you know what I'm saying? So we don't even have the logistical means, at least I don't, to notify a radius of 15,000 people if that were my decision.
Funding to do that.
Huh? Right. So,
good point.
And Delvin, and getting back to that point, it's leaving the council person, it's hanging the council person out to dry is what that is doing. If there is a location where, say they don't notify the council person and you don't know it, and the next thing you know, it's going to come back, why weren't you notified? Why weren't we notified? I think what they do right now in in the zoning and stuff, the 200 feet like that, I think it works out wonderful. I don't understand where I've never said that there was a problem that nobody was notified. I don't know if everybody else did, but at least somebody's putting a fence up, the people around, their immediate neighbors are notified. We are part-time workers is what we are. I mean, we all have jobs, we all have other things going on. To get involved in that and have something in there that says we have to do it, and then it comes back to you, I don't feel comfortable with that, and that's right. That's just what I got to say.
Can I say something? This is Karen.
One second to that. I do think that I do like the idea of there being a communication to the constituents around that business. I think that the responsibility, and I don't really want to put it on the clerk because the clerk's office is busy, right? But I do think that the administration or the executive or the hearing officer, if we're paying that person out of this $500 fee, that hearing officer should notify the constituents within compliance to the ordinance that the code ordinance, on behalf of the council person. I mean, or using our letterhead or whatever, we can supply them with that, a standard template that the clerk can work out. But I don't think it's to be on the individual council person to distribute that letter to the
should be on behalf of the city,
right?
Yes.
Or on
Council
behalf
person,
of the city, right? Yeah,
they pay city taxes. Okay, come on.
Right. I agree.
Councilman Mooney might interject. So is it under the impression that you would like the judge to remove this section that has to do with the common council members in it?
Well, I think we should be notified. I like Section 8 that Section 1. But I do agree that it shouldn't be on us to notify everybody. I think the language should say that the
city will.
The city, yeah.
Okay. Kate, are you there?
I am, Councilman. How are you?
would you please make the appropriate amendments to that section to reflect what my colleagues and what the judge mentioned?
Well, I just want to speak on this for just a second. So I want everyone to be aware that the hearing that is contemplated under this section is not a public hearing as the Common Council conducts public hearings. It does not require legal notice in the newspaper. And I think that this section could have been worded a little bit better because we're not trying to put the onus of noticing a public hearing on any council member. My suggestion would be to just keep that section 1 that says a copy of the hearing notice shall be sent to the district counselor in whose district the subject business is located. I believe that this was Councilman Moody's idea too. And that's it. And then if the council person, when they go to their, their community meetings, their neighborhood meetings on their Facebook page, if they just want to put the message out there, that's fine. We're not expecting them to put any legal notice in a newspaper. And also, this isn't a public hearing. This isn't a public hearing where people show up. People can write letters if they want to. I do not believe we need that section about providing testimony under oath because, again, this isn't a public hearing. It's just a regular hearing. So I think we would. Go ahead.
But if I can, here's what I don't want to happen though, because we have no authority, right? Given this ordinance, we have no authority in who the hearing officer is. That person and that person alone seems like to decide the hearing or makes a recommendation as to if that store is going to be open or not open. But I do think that constituents should be allowed to make the case and that they should be notified to make the case. And what I'm saying is that the city should notify them because you all have the resources to do it.
I agree 100%, Delvin.
So I think then what you're asking then is to turn the hearing into a public hearing.
No, we're saying, I want you to eliminate A and B, Counselor. That's all I want you to do. Take A and B
I'm
out of
happy
there.
to do that. Oh, that's exactly what I suggested.
The district councilman has to be notified of the suspension.
Okay, so we're all agreed to remove A and B on
Let's
that
get rid
section.
of A and B.
Okay, thank you.
Let's move on.
Thank you. I think my business is done.
Yes, Judge.
Section 2. Number 2. We're all good with the rest of this.
Like a bulldog. I love them.
The suspension of revocation, we're all good with this, should be recorded by the stenographer. The owner of the property should be allowed to represent by counsel. All of that is good with everybody on the council. All right, now let's look at section C and D, and I think we're nearing the end. Notwithstanding the provisions above, the director of code enforcement shall be authorized to temporarily suspend a certificate of use prior to the suspension of revocation in the event that the owner or proprietor has failed to maintain good order at the subject business as required by section 214-350, and the proprietor has been convicted of a felony or misdemeanor involving theft or fraud since the time the certificate of use was issued. Is everyone okay with that? All right, D, in the event the chief of police of the city of Utica has commenced enforcement procedures against the proprietor owner to abate a nuisance, that refers to the nuisance, and the rest of those are referring to the licensing of it. All right, section 214-350, failure to maintain good order at the business location. Is everyone okay with this section? We just had a whole conversation about it previously.
Well, doesn't this, this entire section is going to have to be rethought given, right? These all kind of hang together. So, yeah.
Okay.
Yeah.
All right. So who's going to rethink that though? Because is it that we're going to revisit it?
I'd like to ask a question at this point. Given how much input the council has had and how clear it is about the parts that we have problems with, and we have a fair amount of consensus on at least some of that, wouldn't it be the most efficient thing to do for the law department to rewrite this and send it back so that we don't have to do all of this by amendment on the floor of the council? Can you resubmit this legislation, revised legislation?
Yeah, of course.
Between
Okay.
Kate and I, we can revise.
Okay, great. I just don't want to be doing this on the floor of the council.
I am going to ask, has somebody been taking just wondering if anybody's been taking notes, because I do want to make sure we get everything in that the council's discussed.
I'd be happy to talk to you, Kate. I take pretty good notes.
Yeah.
Thank you, Councilwoman.
You're welcome.
Now, I do have a question that this is just a blanketed 4 points. And if the council okay with that's the point I didn't want to put down anybody's thought. But is the council okay with it being just a blanketed 4-point system, like unlawful beer or whatever is the same as prostitution, is the same as controlled substances? It's this. Is everyone okay with the 4-point blanket, violation?
I kind of think that's something that we should discuss. No, I mean, I think somebody.
It says 4, 3, and it says 4 and 3. I'm sorry. It says, and then other ones have 3 to it, but
Okay.
But all those classifications, everyone okay with that?
Which would, if you do 3 of those things, going back to Councilman Beatrice's point, and then we'll probably rethink that later. It's already 7 o'clock. But going back to that point, it would kind of be 3, and then after 3 offenses, then you have a 12-month or 18-month probation.
Yeah. I got a little bit of a problem. Obviously, you guys know I do with that. I got a little problem with it. I don't know, Councilman DeBrango, what do you think about that? I mean, if you're going to get it, you got 3 chances. What do you care the first 2 times? You're going to keep running your place wide open. I mean, if you're running prostitution out of your store, if you're selling drugs out of there, you're going to get your hand slapped. You're going to do it again. I mean, that's my only way of looking at it. Maybe I'm overthinking it, but I don't know.
Well, if you do it again within a 24-month period, you will lose your store. So.
Okay. Some of those are pretty serious offenses. You know what I'm saying? I mean, selling pot might be something, but I mean, booking and selling controlled substances and prostitution. I mean, do we really want people running?
I have a real problem with lumping marijuana in with the rest of this.
Right.
We're all, as a country, moving towards the decriminalization of marijuana. So it seems kind of odd for us to continue to treat this like as serious a crime as,
right,
I don't know, assault or, or unlawfully dealing fireworks. I'd rather have somebody dealing with marijuana than unlawfully dealing with fireworks.
Right. I don't know. I just think that it's kind of like, I think if you're doing that stuff, I don't think we want them in our city. I don't think they should have 2 or 3 chances to keep doing it. And then, I mean, you got your other stores that are right up, just my thought. I'm willing to listen to what anybody says, but it's just saying how I feel.
Mr. Chairman?
Yes.
I'd like to ask Kate a question.
Certainly,
Yes.
Judge.
I was wondering why there is nothing in there about the hours of operation. Are you depending on some other section of our laws, or these convenience stores that these are what I'll say we're targeted? Isn't there a point where because they're in neighborhoods, there should be a closure time? I'm just asking that, and if that was discussed by your framers of this thing, and you had a reason why you didn't want to do that, that's quite all right with me. It's something that just bothered me a little bit. I wanted to mention it, and I wanted to mention it before we adjourn for the evening. So there's no hours of operation, and I would think neighborhood, they've been there forever, but there's no point where some of the people in the neighborhood would wish they'd close.
Yeah.
And what is a reasonable time for that to be, and what have you thought about it? I'm not saying you have to do it, I'm just asking you if it was considered and rejected, and if so, why?
So I think we mentioned a little bit earlier that people in their application would state their desired hours, and if those desired hours were appropriate, they would be incorporated into the certificate of use. So they would be bound by those hours of operation. Now, we also discussed with the council actually having uniform hours of operation, which we could certainly put in this law, And then there was also discussion of certain businesses applying to be relieved so that they could go outside and operate outside the usual hours of operation if they go through a process. So if that is something the board would like incorporated and would like to discuss those times, we're certainly happy to do that as we're making revisions.
Absolutely.
Yep.
Yes, I agree.
Yeah.
Absolutely.
Yep. I agree too.
You know, or once they put their application in, we get a chance to review it and say, they're going to be open till 1 a.m. No, they're not. They're going to close at 11, or else you don't
Yeah.
get the application.
Yeah, but I don't think, Councilman, I don't think it should be all over the board. I think it should be a set time, whether we
You're
agree.
right. You're right. Everybody's treated equal.
Yeah, whether we agree, and in my view, 10 o'clock is fine. I mean, guess what? In today's world now, you got Price Chopper, all those places are closing at 10 o'clock now. None of them are staying open like they used to stay. So there's no reason to have these places open, these corner stores open until 1, 2 o'clock in the morning with everybody loitering around there. That's
right. Well, some people don't have vehicles, and it is a convenience. So,
Absolutely.
you know, and Delvin, I made a good point. Maybe a little bit later on Friday and Saturday nights.
Right.
You know, have a work day the next day.
Yep.
Kids have to go to school the next day. So I'm sure we can come up with a good solution.
Right.
Absolutely.
Okay. Yeah.
Absolutely. Yeah. I couldn't agree more. Okay, so are we good with this section? The other B, C, D, E, and F kind of just talk to the point of the point system, but I think we're going to be revisiting that later once they rewrite it. Section 214.351, notice to owners relative to accumulated points. Everyone okay with that? All right. Section 214.352. The promulgation, right? Did I say that right? Promulgation. Wow, I need to put my glasses on. And I want everybody to know I do have a college degree. The promulgation of policies and procedures. Everyone okay with that, with the composition? That means the Director of Code Enforcement, Chief of Police, Chief of Fire, and the Commissioner of Urban and Economic Development will promulgate the administrative policies, procedures to carry out and give. And so that will make up the board of this. All right, 214.353. Everyone okay with that? Okay, 214.354. And 214.355, annual report to the Common Council. Every year, the Director of Code Enforcement, his or her designee, shall prepare and submit to the Common Council an annual report detailing the number of businesses that have a certificate of use and a number of names and addresses to have had their certificate of use suspended, revoked pursuant to this article, no later than April 1st in the year of which the annual report is due. Penalties, criminal and civil. Section A deals with the criminal penalties. Any owner or proprietor who, having been served with a notice or order to correct or remove any violations of this chapter, who fails to comply with such notice or order within the time period fixed by the Director of Code Enforcement, shall be guilty of an offense. Upon conviction, shall be punishable by a fine of not less than $50, nor more than $150, or punishment for not more than 15 days, or both for each offense. Civil penalty, subject to a cumulative civil penalty of $100 per day for each separate violation from the day set for correction in notice or order until the violation is corrected. Enforcement of civil penalty is outlined. And then it says the enforcement, 214.357. The enforcement by the city of Utica of this article in the manner provided herein shall not be deemed to limit in any manner the city of Utica's authority to enforce the provisions of federal, state, and local laws, ordinances, rules, and regulation against businesses covered by this article. We have completed all 12 pages, folks. Are there any general questions, concerns, comments before we conclude this meeting and allow the Corporation Council and Urban and Economic Development to resubmit this to us?
Yeah, I have just one quick comment. Corporation Council, now when they do apply for their certificate, they're gonna get a copy of exactly what we come up with right here, and they're gonna sign it at the bottom so they know when they read it and understand it fully.
You mean they're going to get a copy of the law so that they understand it and sign it fully?
Yeah, a copy of this section, 214, 354, whatever, all these numbers that are. So
Right.
can we give them a copy so they understand it fully?
Yeah, I think what we would typically do is in the application, we would make them certify that they have read it in full and understand it. And we could certainly provide them a copy of it.
All right, that's all I need to know. Thank you.
Yep.
And under this, there are no grandfather. None of these stores are going to be grandfathered in, right?
That is how it's, yes.
Okay. Great. All right. Any other comments, concerns, questions? Hearing none, Mr. President, I want to, or do we have to make a motion to adjourn?
Someone would have to make a motion to adjourn.
Someone make a motion to adjourn.
I make a motion.
Beatrice,
Second.
I'll second it.
Motion by Councilman DeBringo, seconded by Councilman Beatrice. And with that, the meeting is over. See you all, folks.
Good night, y'all.